Good morning, everyone, and welcome to today's webinar. It's a pleasure, as usual, for the European IP Help Desk to have the chance to welcome you. Today, we're going to cover the topic, what's in a name, plant variety denomination, and their interface with trademarks and geographical indication. Today we have an expert from the CPVO with us who's going to drive through this topic. Thank you very much, Ángela, for being here with us today. It's always a pleasure to welcome you and, of course, listen to you. Before I give the word to Ángela and before we start with our webinar, however, many of you might already remember that the European IP Help Desk is taking a few minutes at the beginning of the webinar in order to, first of all, introduce the services of the initiative and also to make you more comfortable with the GoToWebinar tool that we are using together today. Because you might have already noticed that your audio is muted. We do that because we are expecting a large participation by users, and therefore there could be many background noises that could disturb our speaker, and we don't want that. So you are all muted, and I will be muted as well actually throughout the whole presentation, but that does not mean that we're not allowed to ask questions. All questions are actually very welcome. I will take them all and I will gather them in a Word file, which we will analyze at the end of the webinar and try to do our best to provide you with answers to the topics that have been discussed throughout the presentation. Talking about questions, the most frequently asked question is, when will you receive today's slides and recording? And that is going to happen at the latest tomorrow morning or this afternoon, depending on how fast I am putting them together. This file, the follow-up email, will contain a PDF copy of the presentations that have been used, as well as a link that is going to bring you to our GoToWebinar website and will allow you to watch the webinar at any moment you'd like to. Now let's go on with the European IP Help Desk. Very briefly, we are a service initiative of the European Commission with the main objective of helping small and medium enterprises and researchers mainly to understand and use intellectual property rights. EU-funded projects, researchers and EU SMEs are our main targets. However, the services are open to all physical and juridical persons who are interested in the topic of IP and IPR. We help in a free of charge first line support manner, meaning that none of the services we offer here, you can see them on the right hand side, are under a charge, so nobody has to pay for the services we offer there. And secondly, it's a first line support, meaning that we are a first aid, so to say, towards problems regarding intellectual property rights, but we stop where the work of the patent attorney in a way starts. So we don't draft, for example, patents, we don't draft intellectual property rights application, but we can clarify the condition of your information, for example, and see whether there are roads to protect or not. We do that through trainings like today. Mainly our cornerstone of the services is the website, which is ec.europa.eu/IP-helpdesk. And through the website, you can have access to a large amount of publications which are completely downloadable. And also we have an ambassador scheme, so a person that is experienced in IPR and is also part of the EN network in the country where you might be sitting. And also a helpline, which is a service where the experts of the European IP Help Desk sitting in Alicante will answer directly to any of your questions in different languages like English, Polish, and other languages as well. We offer all these services for the European Union and the COSME-related countries, but if you need similar information or similar services or the same services as well in different areas of the world, there's the China, India, Southeast Asia, Africa, Latin America, IPSME help desks. These are our siblings, and they work pretty much the same way we do for our region, and they do that in other areas of the world. I told you there's a large amount of information available online. Among that, e-learning modules, guides, and case studies that are completely free of charge and for your use to be downloaded. We offer webinars. Today we meet for the cooperation with the CPVO, but we have a large offer until the mid-December, more or less. And as you can see, we have a lot to do together. If you'd like to spend a couple of hours together with us, we are going to be very happy to do that. Regarding this particular collaboration with the Community Plant Variety Office and COPORA, we are going to go on the 2nd of November and on the 6th of December. In case you missed some of the previous appointments that we have spent together, do not worry about that, because you can either write us an email at training@iprhelpdesk.eu, or you can visit our website, and in the e-learning page you're going to be provided also with all the links and recordings to the webinars that you might have missed. Among them, all the 5 you can see in here. And from today also this one here. Also a reminder for our specials, we're going to come with patent protection for EU funding beneficiaries on the 20th of October and on the 17th of November. It's going to be another very important appointment for us. So if you're interested also in the patent topic, that's a good way to be together with us. If you're interested more in commercialization activities, also in collaboration with the European Patent Office, we're going to have From Lab to Market on the 18th of October and on the 3rd of November and 8th of December. So you see a very, very busy calendar for the second part of this year. We're going to be very happy to spend as much time as possible together with you. And if you're sitting in one of the European Union states or also in the United Kingdom, in Turkey or Switzerland, you might be very near to one of our ambassadors. So check out our website, see who are the ambassadors, and you can then get in touch with them and talk about intellectual property and IP rights. There are further learning opportunities provided by the European Commission and other agencies across the member states and also beyond. And I put a couple of them in here. If you're interested regarding them, you can simply click on them. You see there are the links in there, and you can check out whether you might be an applicant for these as well. In particular, we have the Horizon IP Scan, which is a service dedicated to Horizon Europe projects, in which SMEs have the chance to spend time with an expert and analyze their intellectual property situation within the project they are following. And so if you are an SME in the first 6 months of a collaborative EU-funded research project, you might be eligible to have an expert that is going to follow your specific case completely for free. And I will simply go on and that leave you in all this information in your slides, because now I would really like to start with Ángela's presentation. And so I will leave the word to you. Ángela, can you now?
Do you see my screen?
Yes, I see your screen very clearly, and I hear you, so you're set to go. I will be in the background just in case you need something.
Okay, thank you. So welcome everyone to this webinar on plant variety denominations and their interface with trademarks and geographical indications. So as usual, It's a pleasure to be working and collaborating with the IPR Help Desk, and in particular with you, Michele. So thank you very much for counting on us. And well, my name is Ángela Martínez, and I work as a legal officer at the Community Plant Variety Office, the CPVO. And well, before starting, I would just want to stress that indeed this webinar is aimed at or targeted at SMEs, researchers, but indeed normally we see that we cover a heterogeneous audience, let's say, because we have lawyers, non-lawyers, we have persons with little knowledge on the matter. Then we also have sometimes experts, and then we need to provide an added value to everybody. So we are, let's say, accommodating everyone with a middle point, let's say, and then we start with some elementary notions, and then we start edifying on that. So let's begin. So just a little disclaimer. And here on screen, you see the outline of the presentation of today. So first of all, I will start with a very brief introduction to plant variety protection in the European Union. Then I will introduce you to the notion of plant variety denomination. And then we will start exploring what's a trademark and the interface with plant variety denominations. And then we will do the same with geographical indications. And finally, I will show you a bit how these plant variety denominations and other designations coexist in the marketplace. And then I will share with you some relevant databases for your information and some wrap up or final considerations. So starting with the introduction to plant variety protection in the European Union, here you have the premises of the CPVO, so the front door, let's say, the front facade of the main building. So first of all, it is necessary to indicate that there is an international legal framework for plant variety protection. So this is like, let's say, the international context. And the main intergovernmental organization here is the International Union for the Protection of New Varieties of Plants, so UPOV. And UPOV is competent for the regulation and the harmonization of the international framework of plant variety protection. So UPOV was set up in 1961. It has its seat in Geneva in Switzerland, a legal personality, and it counts on 78 members so far. So these members must implement in their domestic legislation the main obligations enshrined in the Convention for the Protection of Varieties of Plants, so in the UPOV Convention. And this convention was the basis based on which the UPOV was set up, and it was adopted in 1961 in Paris, and it was later amended in several times. And the latest act of the UPOV is the 1991 Act, although some members remain members or have joined the 1978 Act. And well, so far there are 23 member states of the European Union that are members to UPOV, and the European Union as such, as organization, become a member of UPOV in 2005. So, as we know, the European Union put in place the Community or European Union Plant Variety Rights System. I will be referring to it as of now as EU PVR system. And this is a sui generis system for the protection of plant varieties in the European Union territory. And it has its legal basis in Council Regulation 2100/94. We refer to it as basic regulation. And the basic regulation is modeled on the UPOV Convention and compliant with it. So it was adopted in 1994. But even if the European Union joined in 2005 UPOV, actually the basic regulation, as I say, is compliant with the UPOV Convention. And well, the EU PVR system is managed by the CPVO, which has its seat in Angers, and it's operating since 1995. So very fast, I will I will just let you know that there are benefits, there are important benefits to this procedure for an European Union plant variety right, because with anybody can apply for protection, and with one single application that goes through one single procedure and one, let's say, examination, which is triple-fold, because we have the formal examination, the substantive examination, and then we have the technical examination, where we examine the varieties on field, and then we get to a single decision. And if this decision is positive and the application is accepted and we grant the title, then this title is valid and enforceable in the totality of the territory of the European Union, so covering the 27 member states of the EU. So as I say, I want to stress that this is a type of uniform European Union protection, so the same as what we have for European Union trademarks and community designs. So this means that the title, well, they say like the right, can only be granted, transferred, or terminated on a uniform basis. And it is valid, as I say, throughout the territory of the European Union, the totality. And plant variety right of the European Union lasts for 25 years from the time of the grant, and 30 years for some specific species. Now, let's go to the subject matter of protection of a plant variety right. So what is it? It's the plant variety, and you find the legal definition in Article 5.2 of our basic regulation. But, well, you see here on screen the legal definition, but in any case, in simple terms, I want to convey the message that a variety is the most specific and the tangible unit of organism in the taxonomy of the plant kingdom. So to illustrate it a bit more, we know that, well, taxonomy is a discipline based on which we classify any living organism in the world. So we have a kingdom for animals, we have other kingdoms, and here we are focusing on the plant kingdom. And then we have this inverted pyramid where we have the kingdom, then we have the class, and most importantly, if you go down, we have the genus. Which here the genus would encompass, well, malus. So basically this is the example of apples, and genus would encompass like wild and domestic apples. Then here we go to the species, and we have the example of domestic apples. And then finally we get to the tangible unity, which is the variety, because all these categories remain theoretical categorizations, but the tangible unit that you can see is the variety. And here we have the example that you may already know, which is the apple Granny Smith. So, well, so far we protect any genera and species. So far we have received applications for varieties belonging to more than 2,400 plant species. And regarding the requirements for protection, so actually the variety denomination is one of them. That's why I wanted to have, first of all, the full picture. So what are the requirements? So we have, first of all, 3 technical requirements, which are altogether referred commonly as DOS requirements. So distinctness, uniformity, and stability. So distinctness means that the variety must be clearly distinguishable from all the other varieties of common knowledge, at least clearly in one characteristic. Then we have the requirement of uniformity, which means, for instance, that if you observe the flowers of the plants, they must all look alike, homogeneously, let's say. Then we have the requirement of stability, which means that the variety must remain the same after repeated cycles of propagation. Then we have the criterion of novelty, which is to be regarded as a commercial type of novelty. So the variety must not have been commercialized before, but there is of course a delay of grace during which we allow exceptionally that the variety has been commercialized. And then finally, we have the obligation to designate the variety via variety denomination, and this is the focus of our presentation today. So briefly, what is the scope of the European Union plant variety right? Well, with the plant variety right, you get an exclusive right or an exclusive monopoly to authorize or prohibit the following acts that you see on screen. So production of reproduction or multiplication of the material, conditioning for the purpose of propagation, marketing, exporting or importing to the EU, or stocking for any of these acts. And this is in relation to propagating material of the variety, so the variety constituents, the seeds. And then the right can also be exercised in relation to harvested material, so the fruits or the flowers, but there some specific conditions apply. So in general, we need to keep in mind that we are referring here to the upstream level of the propagating material. Now that we know that the plant variety denomination designation is a requirement for the grant of the European Union plant variety right, let's explore a bit what it is. So first of all, in case you wish to research more about it, I indicate what is the legal framework where we can find all the aspects of denominations regulated. So first of all, I must mention the international level, so the UPOV Convention again. There, the cornerstone is Article 20, and there you have all the specific aspects of denomination listed. Then, at European Union level, as I mentioned, we have the basic regulation, and then you should go to the articles that you see there on screen. And then another very important, let's say, legal basis, but here I want to stress that this is not part of the plant variety right, which is system, which is like an industrial property system. Here we are talking about the European Union system for the marketing of plant material, which is separate and independent from the plant variety right system. So here, if you wish to commercialize your variety, then you need to have it listed and authorized for marketing. And there, one of the requirements again is the plant variety denomination. And then if you wish to protect your variety with our system, and then at the same time you also want to commercialize it, then the denomination should be the same in both registers. Because in the end, in the market, there is only going to be one variety. So of course, we need to have the same denomination for identification purposes. And here the regulation that applies is the Commission Regulation 2021/384. So as we take into account also this regulation in the sense that we must have equivalent requirements. And well, that's why we integrated into the CPVO guidelines with explanatory notes on denominations. So first of all, I want to let you know that there is also at UPOV level some explanatory notes on denominations. The last version was of September 2021, and it has more or less 20 pages. And then, well, there is actually a working group at UPOV level that works on denominations. And then we also have our own guidelines with explanatory notes. So the guidelines, we actually have two different documents if you go to our website, because we have the guidelines, which is shorter, and it has like the, let's say, some developments of the main provisions on denominations, and that is approved and endorsed by the Administrative Council of the CPVO. And then we have another document which includes the guidelines and also explanatory notes. And these are, let's say, practical examples, and it's more like a user-friendly document, and the Administrative Council takes note whenever we introduce a change. And that's around 70 pages long, and it's available on our website. So that's a bit the legal framework in case you want to explore yourself later on this matter. Now, the plant variety denomination, again, what is its legal nature? So we have seen that it's a requirement for the grant of the plant variety right. And what is it? It's the unique and generic designation that we attribute to a specific variety. So we bring a new variety into the world, and then we must christen it with a name. And well, it's a product name then in the end. And then It's important to stress that the plant variety denomination, it's not a right. We have seen that it's a requirement for the grant of the plant variety right, but it is to be considered as a regulatory element. Then the plant variety denomination, well, there is a very interesting element here because which is its universality. Because at UPOV level, we have the obligation that a variety must be submitted to all UPOV members under the same denomination. Because in the end, we know that we have a global supply all year long of varieties in the world. There is globalization. And in the end, we want to see the same denomination in any place in the world. So this is a rule that applies to all UPOV members. And the authorities of each UPOV member must register the denomination submitted as was submitted in other authorities, unless they consider that the denomination is unsuitable within its territory. So in this case, a synonym would be created, but let's say that this should be the exception to the general rule, because the general rule, and it's very important, and you have it here on screen, is this golden rule that one variety must get one denomination everywhere in the world. So to this end, it's very important to establish a good interinstitutional cooperation among the authorities of UPOV members. So it's important to keep each other informed regarding matters concerning denominations. And well, for this reason, for instance, at European Union level, we always publish in a register denomination proposals, and then at the same time, then afterwards we publish the registered denominations. So what is the function that a plant variety denomination performs? So, well, it serves a product identification function because it enables users in the marketplace to distinguish a specific variety from others. And the use of the denomination is a mandatory obligation for any person commercializing in the concerned territory propagating material of the protected variety. So any person means that this obligation is not just for the holder of the right, of the plant variety right, or its licensees, but it also applies to any user, well, any person commercializing the variety. And then it's important to stress that this requirement applies even after the expiration of the right in that variety. So this is very interesting because let's say that the denomination is destined to become the generic designation of the variety, not only during the lifetime of the plant variety right, but then also after the expiration of the protection. So it outlives the plant variety right, so to say. And in this way, let's say that at the beginning, it's a condition for the grant of the right, but then it becomes, let's say, like an independent element from the right, if you want to see it like this. And well, the idea is that the mandatory use of the denomination contributes to the regulation of the market in the agri-food sector because it prevents any sort of misleading of the public, and let's say that it serves a general public interest. Now, who are the users of varieties? Or here I mentioned the word relevant public because I know that this is the concept that many trademark users, trademarks examiners think about or use in a daily basis. So for this reason, who are the users here? Well, we need to think that this is the denomination is an obligation applying to the propagating material, so to the seeds, to the, as you see on screen, any person getting a seed in their hands needs to know what is the variety that we're talking about, and that may not be visible by checking the seed. You're looking for a specific characteristic, and you want to know what is the variety that you have. You're looking for a specific one. So for this reason, the denomination is very important because it allows to identify the material of a specific variety. So here, the main public targeted by varieties that are designated by denominations is the professional public. And However, a more general public that covers also average or end consumers may not be disregarded. Now let's explore a bit this notion. So the professional public is made up of professional or experts in the sector concerning the production or the marketing of plant varieties. So who are they? So breeders, seed distributors, seed propagators, licensors, cooperatives, and so on. They have or they exhibit a relatively high technical and biological knowledge of varieties, and they place their emphasis on product performance and technical specifications, meaning they're looking for a specific variety. So they know what they want, and they are looking for a specific variety identified by the denomination. But nevertheless, sometimes we need to consider a broader public, which is made up of specialized non-professionals and also of end consumers. So here we consider plant amateurs that have a good technical knowledge of varieties, and they acquire the material at nurseries. And we need to consider consumers that purchase plants or flowers or propagating material in specialist retailers in horticulture. And there is also, well, a part of the public is made up of uninformed consumers that they're often unaware of plant variety denominations, and they get plant-derived products in a generalist retailer. So there are some specificities depending on the market sector and type of crop. So for instance, in the fruit-related market, let's say that denominations enjoy a greater visibility. And here the end consumer may display an enhanced attention level to denominations. So an example would be the example of well-known apples, because I go to my next screen, to my next slide, you see here some popular names or denominations of apple varieties. And I'm sure that here anybody watching this webinar today knows how to distinguish the crisp pink variety with its specific technical attributes, or let's say the flavor, the crunchiness, and so on. And you can distinguish it perfectly from Granny Smith, from Golden Delicious, and so on. Now let's get to the process of proposing a plant variety denomination and registering the plant variety denomination with us. So the proposal must come from the part of the applicant. So it's the applicant that proposes to the authority, in this case, the CPVO. And there are some suitability requirements that must be respected. And if the denomination proposal does not satisfy them, then at the CPVO, we must refuse to register this denomination, but nevertheless, we give the chance to the applicant to propose a new denomination. And then, of course, we need to again examine it. And then finally, if the denomination is considered suitable, then we can register it at the same time as that time when the plant variety right is granted. So, what are the suitability requirements in a nutshell? So here we have the cornerstone in the UPOV Convention in Article 22. So the most important part, or the principle that we must bear in mind, is that the denomination must be able to identify the variety. So the users must be able to identify it immediately. And for this reason, the denomination should not be liable to mislead regarding the variety's characteristics or value or identity, or cannot mislead either regarding the breeder's identity. Because here, for instance, we have some companies that use an abbreviation that identifies the company actually when they designate the variety by a denomination. So for this reason, when we know that a certain abbreviation is the one that a company uses, normally we don't accept when somebody else comes and tries to register a denomination with the same abbreviation, let's say. And then, well, the denomination must be different from that denomination of another variety of the same plant species or of a closely related species. And I will go to this notion in a moment afterwards, this notion of closely related species. So where do we find these requirements for suitability in the basic regulation? Well, you need to go to Article 63 to the third and the fourth indent. So here on screen you have the third indent, and you see here the list of impediments to the registration of a denomination. So these, let's say, are, or we can compare it by analogy to the absolute and relative grounds to refusal under trademark law. And here, for instance, we have when the use in the European Union territory is precluded by the prior right of a third party. So actually, this is the impediment that we will be checking today in this presentation. And then we have other impediments that you see on screen. I will not go by detail, but of course, the denomination should not cause difficulties as regards recognition or reproduction. It should not be liable to give offense. So we also have this public policy impediment, and should not mislead or cause confusion, and so on. Then the other impediment that we find in the fourth indent of Article 63, again, it's a crystallization of this UPOV principle that one variety must have the same denomination everywhere. So if it comes to our knowledge, or if we know by checking in our system, we check and we know that this denomination, well, this variety has already been registered either in a plant variety right register, in a commercial register, or has been marketed under a given denomination, then we should have the same denomination in a register. And if we see that it's different, then we raise this observation to the applicant. Sometimes, if there is an impediment in our case and we cannot keep the same denomination because another impediment arises, then in that case we create a synonym. But as I say, this should be regarded as an exception to the general rule. Then, of course, we publish proposals for denominations, and there is a period during which an objection can be lodged. This period is of 3 months from the date of publication of the denomination proposal. Any person can object to this proposed denomination on the ground of an impediment, of the impediments that we have seen. And in the case where we actually uphold this objection, then the applicant must propose a new denomination. And in the case where we dismiss the objection, then this objector always have the chance to appeal the decision that we take, well, has the chance to appeal at the time of the grant of the title before our Board of Appeal. So what happens once we have a registered denomination? Is it forever? Is it definitive? Well, there is always a chance to amend the denomination, but it must be for good reasons. So the CPVO must actually amend the registered denomination if that denomination no longer satisfies the conditions of suitability enshrined in Article 63, and in the event of a conflicting prior right of a third party. So in these cases, the holder of the right must propose an amended denomination, and then the same procedure goes on. So the CPVO checks the suitability, then the new proposal is published, and then there is again an objection period. And well, at the office, we have actually, just to explain a bit like the team inside, we have a team of denomination examiners. So for now, we have 2 examiners. And then we also have the manager of the Variety Finder database. I will talk about the Variety Finder in a moment. And we also have a committee that is devoted to the matters concerning denomination. So more precisely, decisions taken regarding the approval of denominations and the amendment of denominations. And this committee is composed of 3 members. So 2 of them are technical and 1 is legally qualified. And here on screen, you can see that the VDC, well, some of the tasks, the main tasks that the VDC carries out. So it's, as I said, ultimately responsible for decisions on denominations. It also takes decision on objections, responds to consultations of the denomination examiners, and so on. So now we come to a quiz that I prepared for you. which is guess the denomination. And here you can see on screen a variety, and I want you to think for a moment what could be the denomination, because sometimes denominations can be very, let's say, insightful or very funny. So this one is called Velvet Delight. So no reason to explain in detail, because you may understand why. I also leave here some hints. So this one is Purple Rain. This one is Olympic Golden. This one is Freckles. This one is Bengal Tiger. And this one is Candy Hearts. So why did I want to share this quiz with you? So the idea is to show you that naming plants, naming varieties is a world of its own, and sometimes breeders think of very creative names or names that have something to do with the variety, with the characteristics of the variety. Sometimes they evoke them, or sometimes, and this is my last example, sometimes they are named after celebrities or after relevant persons. And here actually the variety on the left is called Picasso, like the cubist painter from Malaga in Spain. And then the one on the right is Vincent van Gogh. So we know that in the Netherlands they have a very strong business with ornamentals, and in particular, of course, with tulips. So for this very special, let's say, black purplish tulip, it's nice that the name was, that the variety was named after probably the most famous painter in the Netherlands. So now we will see in a nutshell trademark rights. So a trademark is a sign that serves to indicate the commercial origin of the goods or services in relation to which it is used. So when we're speaking about goods, we are referring to products on which the trademark can be physically affixed, so by labeling or in a packaging. So products, any products that you can imagine, computer, mobile phone, and so on, of any type. So here, for instance, we will be checking today the products of plant-related material. And the services are any activity of an intangible nature, so financial, banking, travel, advertising, and so on. And well, in applications for our trademark rights, the goods and services must be classified in accordance with the so-called NIS classification system, which is a system established by the NIS agreement concerning the international classification of goods and services for the purposes of the registration of marks. So here on screen, you see a screenshot that I took of the portal of the NIS classification. So for class 31, which is the one that we will be checking today, so that you can have an idea of how it looks like. And well, there are different types of trademarks. So because trademarks can consist of words, so they can be denominative, or they can be figurative, or they can consist in designs, in colors, in the shape of the goods or the packaging, or even on sounds. And what is the function of a trademark? Well, the essential and originary, let's say, function of a trademark is the designation of or indication of the commercial origin, as we have seen. So the trademark must be able to distinguish the goods and services of an undertaking from those of other undertakings in the marketplace, because the consumers, they need to be informed about the facts that the products or the services that bear design, they have been originating, they originate from a certain undertaking. So they have been produced or marketed by this undertaking. So, well, this contributes, of course, to the public interest of the good functioning of the market and the promotion of competition. And well, the Court of Justice, just for you to know, but I won't go into the details because this is quite a substantive case law that we would be talking about. But the Court of Justice of the European Union has also recognized other functions of trademarks. So regarding the quality assurance or advertising and the communication aspect with the consumer. So a trademark can enjoy a legal protection under a trademark right. So trademark applicants can apply for protection at national level, at regional level, or at international level by means of the so-called Madrid system, which is managed by the World Intellectual Property Organization. So just for you to know. And in what concerns the European Union territory, the national trademark systems of the European Union member states are based on a national law, and this national law is harmonized by virtue of the trademark directive, so to ensure that we have the same substantial requirements for trademark registration in all member states. So at European Union level, it is possible to obtain a European Union trademark right with unitary character. So just like in the case of European Union plant variety right, this would be a right that is valid and enforceable in the totality of the territory of the European Union. And to apply for this right, you would need to apply before the European Union Intellectual Property Office, or EUIPO, which has its headquarters in Alicante, in Spain. And the legal basis applicable here is the Regulation 2017/1001 on the European Union trademark, or we call it the EU TMR, or the European Union Trademark Regulation. So once registered, what the trademark holder gets is like an exclusive monopoly based on which it has exclusive right to use let's say, prohibit or authorize the use of the sign in relation to the goods and services in the marketplace. So actually, the licensing of the trademark right can consist a powerful business tool to create revenue streams. And also, it's important that the trademark holder can prevent any third party from using the same or a confusingly similar sign for the same or for similar goods or services. And then this right has a duration of 10 years, but it can be renewed indefinitely for periods of 10 years. So there are also absolute grounds. So like we have seen the impediments to the denominations. So for European Union trademark applications, there are also some absolute grounds for refusal, based on which protection can be excluded or refused. So there are several, well, there are many grounds. You can find them in detail in Article 7 of the European Union Trademark Regulation. But for instance, the trademark must not be devoid, to be registered, must have a distinctive character. It must not be descriptive of the characteristics of the goods. It must not be generic, and so on. And it cannot conflict with an earlier protected geographical indication or appellation of origin or a denomination. So when EUIPO considers that the trademark application fulfills all the requirements, the application is published in the European Union Trademarks Bulletin, and then there is an opposition period of 3 months from the time of publication of the application, during which anybody can object or can oppose to the proposed application. So here we can see an example of a trademark in relation to plant varieties, as this is the topic of today. So we see the very famous trademark Pink Lady. And Pink Lady, well, there are several trademarks actually registered with EUIPO with different types. And in this case, it's one registered for class 31 in the NIS classification, which, as we have seen, is the class devoted to agricultural and horticultural products, and the one of interest when we check conflicts with denominations. And in this case, in practice, the trademark is used for different varieties in the marketplace, so including the crisp pink variety. Now, let's check the interface between plant variety denominations and trademarks. So here, a brief comparison, as we have seen, because we have now explored the denominations, we have explored now trademarks. So just a quick recap. So the trademark, the function that it has, it's designating the commercial origin of the goods and services that appear on which the trademark is affixed. And then the denomination is a generic designation to identify the variety. So the trademark right can be renewed endlessly, so there can be an indefinite period of protection, whilst for the plant variety right, there is a limited period of protection. And then the trademark right, so here the trademark is on the sign, but for a plant variety right, the IP right is on the variety, not on the denomination, because as we have seen, the denomination is a requirement for the grant, and then it's also, let's say there is an obligation, a duty to use the denomination in the marketplace. So let's see now how trademarks can be a prior right vis-a-vis denomination proposals. So, well, prior rights of third parties we have seen can constitute an impediment to the suitability of a denomination, and very often the conflicting right that we identify is a trademark right. So in the cases where a denomination proposal, we carry out a check and we identify that this denomination is identical to a prior registered trademark right for an identical good. So when I say identical good, I mean that in the list of goods and services of this trademark, we identify, well, the variety that the denomination designates is encompassed in this list of the goods and services. And then if this is the case, then the CPVO informs the applicant about it, and then the applicant can make a new proposal. Now, from the other perspective, when we go to European Union trademark applications, we can also find that denominations can conflict as an earlier prior right. So we have Article 7.1m of the European Union Trademark Regulation, and this is the specific and exclusively devoted absolute ground for refusal to the registration of a EUTM application that conflicts with a prior denomination. So actually you find more information about it if you want to check in detail in the EU-IPO examination guidelines, where everything is detailed and it's very easy to understand the process of examination. And going to the article, so we see that trademarks cannot be registered if they consist of or reproduce in their essential elements and a denomination of a plant variety right that has been registered earlier than the date of the trademark application. And then this variety must correspond to the same, the trademark application, the list of goods and services must somehow contain or must encompass the variety of the same or a closely related species. And now let's explore this notion of closely related species. So, well, the idea is that varieties belonging to a different species, but within the same genus, they are to be regarded as closely related, like in botanical terms. So at EUPOB level, there is this general rule that where we have different classes, and then for every genus we have one class. But however, there are exceptions to the rule, and the exception is that some varieties belonging to the same genus, so to the same, this would be the same class, are not regarded as closely related species. And then sometimes we have the other possibility that some varieties belong to different genera, but are grouped within the same UPOV class. And this is done to, well, to reflect the specific market realities. We will see that now in a moment. So here we have the example where we have the general rule, one genus, one class. So we have the example of Phaseolus. So here we have the specific species, Coccineus, vulgaris, Acutifolus. So in all these cases, they all belong to the same genus, and that's to be regarded as one class. So this means that two identical denominations for varieties belonging to one of these closely related species could be a problem, because this could be considered as liable to give rise to confusion. But then we have exceptions, as we have seen. So we have the exception where the species belong to the same genus, but are in different UPOV classes. So here we see tomatoes, we see potatoes, and we see eggplants. So in this case, varieties of these species could be granted the same denomination, because there would not, it's considered that when these varieties go to the marketplace, there would not be an issue of confusion to the cost to the users. Then on the other hand, as we have seen, there is also the exception that the species belong to different genus, but are nevertheless grouped within the same UPOV class, because they share similar characteristics. And here on screen, you can understand why when checking the pictures, because you see that they are very similar. And well, in this case, even if they are in different genera, we cannot use the same denomination, because there could be an issue for the users in terms of confusion. Now, in practice, let's see Article 7.1m, so how it is applied. This is just a quick example that you find in the examination guidelines of EU-IPO. So here we see that there was an applicant applying for the figurative sign Gioia Crea Bontà. And here EU-IPO observed, the examiner observed, that Gioia is registered for a variety within the genus Dianthus, and in the list of products and services, this variety would be covered in the European Union trademark application. So here, indeed, the size and the position of the denomination Gioia, it's in a very enhanced or prominent position in design, and the elements Crea Bontà are in a secondary position and, let's say, negligible. And in this case, what EU-IPO does is that there is a proposal to limit the list of goods in the European Union trademark application, so that the plants belonging specifically to the botanical genus Dianthus, so where there is a conflict, they are excluded. So this was the solution that was found in this case. Now, I won't go into the details, and there are many other cases, of course, but I just want to share with you some of the most landmark, let's say the landmark cases in the case law of the boards of appeal of EU-IPO and also of the Court of Justice of the European Union. So these are some very interesting cases that I invite you to check. And now let's go to the matter of geographical indications. So exploring what they are, and then understanding what is the interface with plant variety denominations. So a geographical indication is an intellectual property right on the name, which serves to identify the good as originating from a specific geographical area, and where this given quality or reputation or any other characteristic of the good is essentially attributable to its geographical origin. So the geographical indication, it confers like an exclusive collective right on all the producers in the defined geographical area, who must then abide by the product specifications or conditions to use the geographical indication. So they actually tell the buyers of an item that are interested in an item that this item or product has been produced in a given place and that it has certain desirable characteristics that are only found in items originating specifically from that place. So that's the idea. And these are, so to illustrate what geographical indications are, you see on screen some examples. So we have Limone di Sorrento, we have the cheese Roquefort, we have Champagne. And regarding the functions of a geographical indication, well, first of all, there is the public interest in that consumers can perceive a geographical indication or can perceive this name as denoting the origin and the quality of the products. And there is also the idea that it serves like a tool to promote traditional knowledge and the local development in some areas, and then it fosters, of course, investment in the quality of the local production. Now, just to let you know that the legal framework for the protection of geographical indications in the European Union is relatively complex. So you can see here the different regulations that apply depending on the specific product concerned. And also important to stress that we are currently in a moment of legislative reform of the European Union geographical indications framework. So for now, there is a proposal for the Commission that has already been published in March 2022. The idea is to strengthen the geographical indication system. And I invite you to check the page of the Commission where you can find more information in case you're interested about what is this legislative reform about. So also important to let you know that there are actually different types of geographical indications, so to say, and we have on the one hand a protected designation of origin or PDO, then we have a protected geographical indication as such, so as PGI, and then we have traditional specialties guaranteed, so TSG. And you may know when you go to the marketplace, you may realize that there are different signs. So now you may understand that each corresponds to a specific type of indication. And just very briefly, because we are limited in time, so I'm just going to give a brief overview. Regarding the protected designation of origin or PDO, this applies to a name that identifies a product that originates in a specific place or region or exceptionally country. And here the quality or the characteristics of these products must be essentially or exclusively due to a particular geographical environment. So more precisely due to the inherent natural or human factors of the geographical environment. And here it's important to stress that all the steps of production that of this product must take place in the geographical area concerned. So this is a big difference with protected geographical indications, because here we only need at least one of the production steps to take place in this concerned geographical area. And then finally, we have traditional specialties guaranteed, so TSG. And in this case, actually, this quality scheme does not certify that the protected product has a link to a specific geographical area. So here, actually, what we are trying to safeguard is the traditional methods of production and recipes. So let's say that we protect like the mode of production or the composition and the traditional practice of producing a given product. So I will share the slides, or Michele will share the slides of this presentation afterwards. So for this reason, I included some screenshots from the European Commission website devoted to indications of origin. So here you will be able to see them in more detail if you want to learn more. And very briefly regarding the process of registration of geographical indications. So So just for you to know, the applications for a geographical indication can be filed by the producer group. So it must be like an association of farmers or producers, processors that produce the same product. So I want to stress again that this is to be regarded as a collective right. And then the product must be defined according to some product specifications. So what are these product specifications? So in these product specifications, we need to specify what is the product concerned. So for instance, specific varieties that are covered under this name that we want to register. Then we need to delimit what is the relevant geographical area. Then if there are any conditions for the production of the product, then we need to specify them. So for instance, there is an example with apple varieties that are covered under a geographical indication, and there we would need to specify, okay, because of these geographical conditions of these climatic conditions of this area, the apple of this variety must have this specific level of sugar content or any other qualitative aspect, let's say. So these are the product specifications and are very important because once this geographical indication is registered and approved, then anybody in the area that wants to make use of the name of this geographical indication must abide by these product specifications. So regarding the process of application, so the application must be filed by this applicant group before the authorities competent for this in the European Union member states. So there is first a first examination of the application by the national authorities of the European Union member state concerned, and there is also a national opposition process opened, and then the national authorities can take a decision and they approve it, and then they forward the application to the European Commission. And then when the European Commission receives the application, it assesses it, and if it considers that all the conditions are fulfilled, then it publishes the application in the official journal of the European Union. And then from this date, the authorities of a member state or also of a country, of a non-EU country, or any natural or legal person having a legitimate interest can also lodge a notice of opposition against this geographical indication. And if no objections or oppositions are received, then the geographical indication can be registered. So again, very important to stress that once registered, any producer that is located in the geographical area and complies with the conditions in the product specification can use this registered geographical indication. So regarding the interface between plant variety denominations and geographical indications, so we have seen it for trademarks. Let's see now for geographical indications. So again, I like showing this comparison to do a little wrap-up of the notions that we have explored. So the geographical indications is an intellectual property right that serves to stress that there is a link between a given geographical area and a product. And well, there is it has the period of protection can last for an indefinite period, and the intellectual property right is on the name. And well, for denominations, you see here again in the right the characteristics, but I won't go through that again. And well, it's important for you to know that when we get a denomination proposal, then earlier geographical indications can constitute there can be a conflict. So we regard them as an earlier prior right in the sense of Article 63 in our basic regulation. Then we follow, because of course, as I was mentioning before, this Commission regulation on the suitability of denominations, it's important for us because even if it's, let's say, part of the system for the marketing of plant varieties, and this is something with which the Commission is concerned, and it's an independent system, we still need to apply the rules in a, let's say, consistent manner. And we also, let's say, adopt or borrow some ideas and reflect them in our guidelines. So if we go to this Commission regulation, if we go to Article 3, we see that a denomination cannot breach or cannot run counter to the articles of the that you see on screen. And so these articles are legal provisions of the regulations concerning geographical indications. So as we have seen, it's quite a complex regulatory framework and there are different regulations, but here on screen we see the articles that a denomination cannot breach. So basically a denomination, we cannot register it as a denomination that contains or let's say constitutes, or it's the same as a geographical indication, because there we would have a conflict. And here, just to show you the example, because I show you different provisions on of the regulations on geographical indications, I've taken regulation 1151/2012, so the regulation on equality schemes, as we call it. And here we can see that the registered names or the registered geographical indications or designations of origin and so on, they shall be protected against any direct or indirect commercial use of a registered name, where the products are comparable to the products registered under that name. And actually the threshold of protection under a geographical indication right is very high, because it also covers any sort of misuse, imitation, evocation, any misleading indication as to the provenance of the product, and so on. So the idea that I want to stress is that the protection granted with an geographical indication is very strong. Now, also, when we look at it from the other perspective, so the perspective of lodging an application for a geographical indication, so there also earlier or prior denominations must also be respected. So when we check a geographical indication application, then also it should not conflict with an earlier denomination. So there's this sort of reciprocity between the two systems, so to say, in simple terms. So here, if we go to Article 6, indent second of the regulation on the quality schemes, we see that a name may not be registered as a designation of origin or geographical indication where it conflicts with a name of a plant variety and is likely to mislead the consumer as to the true origin of the product. So these are the two conditions. It cannot conflict with the plant variety, and it cannot mislead as to the origin of the product. So in the end, the idea or the message that this provision conveys is that there is a public interest in that users are not misled as to the product they acquire. And finally, I prepared also a section for you on the coexistence of plant variety denominations and all these other designations that we have seen in the marketplace. So, because on the one hand, okay, one thing is the registration, that we must ensure that there's no conflict, but this does not mean that in the marketplace, in a package, we cannot have, let's say, like a trademark and then combined with a denomination, like this is allowed actually. So let's explore it a bit in detail. So we actually have a legal basis recognizing that it's possible that denominations coexist with other designations. So we have here on screen Article 28 of the UPOV Convention. So here, in essence, as I say, it recognizes that we can associate a denomination to a trademark, a trade name, or any other designation. But there is the condition always that if there is such association, the denomination must always be easily recognizable. So then this obligation has been embedded also in our basic regulation in the European Union. And here again, we stress that the denomination must be readily distinguishable and clearly legible. So here on screen, we have an interesting example where of wine labeling, where we find a trademark, Viña Gormaz. We also find a variety denomination, so Tempranillo variety, and then we find a PDO, which is Ribera del Duero. This is another interesting example where we again find a GI, and then we also find a trademark, and then the denomination. So, well, here Marlene would be the trademark. And I was checking the register, and I see that they have registered the trademark for in all versions. So Daughter of the Alps, they have also registered it in the Italian version, the German version, and the Spanish version, and so on. And here, well, just to mention that they have actually these producers in the area, they have registered their own geographical indication, which is Mela Alto Adige. And well, the idea is that the product specification, they indicate that this is the name protected. Then the varieties concerned must have certain qualitative characteristics. And then the territory concerned here is the Bolzano region in Italy. And then they establish specific conditions, for example, that the soil must have, and so on. And these would serve to, let's say, certify the quality of the product based on its origin. So here the product would be the different apple varieties that you see on screen. And they would have specific qualities that are attributable to the geographical area that I mentioned, the Bolzano area. And in essence, they also guarantee under these geographical indications that there is a whole quality control system that, well, it comprehends quality checks that go from the harvesting of the fruit to the transport. So there is a, yes, a very comprehensive system of quality checks. Now, when we check the coexistence of trademarks and denominations, it's important to distinguish these by different notices. So in the case of denominations, we normally use single quotation marks. Then here there are more examples where you can see the use of a secondary trademark combined with a primary trademark of the firm. Then we have the species name, and then the denomination there in little, like Queen of Night, as you can see. This is another example. So chameleon would be the trademark. And then these are the denominations. So here, for example, we have Hair Alexandra, which is a very nice name for this variety. And well, some recommendations for the breeders are there on the combined use of trademarks and denominations. Well, it's important not to associate a trademark with a specific denomination, because then the user may understand that this trademark is the denomination when this is not the case. And then the trademark would become generic. Then it would no longer serve to perform the designation of its function of designating the commercial origin, and then it can be liable to cancellation. So it's better to, well, it's recommended to use the trademark for a wide variety of a product range of varieties that have similar characteristics. And then the use of a single trademark should be avoided. And then, as I said, it's important to use single quotation mark for denominations or to distinguish what is a denomination from a trademark. And then it's important also for the trademark owners that license the right that they set up clear guidelines or usage protocols of the trademarks with third parties, and they ensure compliance, and they proactively monitor that the designations are used in a correct manner. Then relevant databases, I will go very fast through these just for you to know that we have a variety finder database where you can search well, denominations of varieties. You can. It also contains all the EUIPO trademark registrations for signs registered in relation to products in class 31. And yes, in case you would have any consultation, any doubt, the colleague that is responsible for the management of this platform is Carole Bonneau. Here are some statistics. Here you can see a bit how it looks like. You need to authenticate and register, and then you can carry out searches, and you can actually carry out testings of denominations to see if there are conflicts with earlier rights. So this is how it looks like. You can search by different criteria, so the denomination or the Latin name or the breeder's reference and so on. There is also a video on a website that was released recently, so it's a 2-minute video where you can learn a bit more about how it works. Then here some databases for searching trademarks. Here there's eSearch case law. It's for the, as its name indicates, it's for case law. Then for geographical indications, we have the eAmbrosia database of the Commission, and then we also have the GI view, which is more recent, and it's a project of the Commission with the EYPO. And then some final considerations. So to close my speech today, just to let you know that there are some commonalities between denominations, trademarks, and GIs, because they are all designations that are on the marketplace, and they communicate to the consumer certain aspects so that they can facilitate, in a way, purchase choices in a competitive environment. This is little wrap up for you to confront the main ideas for trademarks, GIs, and denominations. And again, so as a final wrap up, so it's important to underline that denominations, trademarks, and GIs have a different legal nature and function, that the different designations can coexist in the market under certain conditions, but nevertheless, we must ensure that there are no, that they are, let's say, identifiable in the eyes of the consumer, of the user. And actually combining different forms of intellectual property can represent, of course, a powerful strategic business tool. And to do so, of course, it's important to have solid knowledge of all the different features of the rights and the areas of interface. And then we must also avoid any conflict among rights. And then for the examiners, it's and also for any applicant that wants to apply for a plant variety right or a trademark, it's important, or it's recommended, to make use of the search tools and databases available. And then from our perspective, so from the part of the public sector, it's also important that there is a strong, enhanced interinstitutional cooperation between authorities, because of course, intellectual property rights, they are not in a vacuum, but they are in a whole holistic context where there are many relationships with other factors. Actually, we have seen that there are different intellectual property rights can be intertwined. So for this reason, cooperation is very important. And with this, I close my presentation. And you have here my contact details in case you would like to ask any question at a later stage. And thank you very much. I remain available for your questions.
Thanks to you very much, Ángela, for this very insightful presentation. I am going to show now the questions that have already been written down by some of the participants. I hope, of course, you cannot see them. They're here. For those of you who were not here at the beginning of the webinar, I wanted to mention once again that you receive the slides and the recording of the webinar as soon as possible, meaning either this afternoon or at the latest tomorrow morning. And we can go on with the second question, which is, as to the same denomination in all UPOV member states, how about denomination in Chinese characters, since all characters are translated into Chinese for applications in China? First of all, is China in UPOV? I don't know.
Yes, it is
Okay.
in UPOV. It's it has joined UPOV 78, and yes, there is in the UPOV explanatory notes on denominations, there is a part, if I'm not mistaken, on the transliteration of characters. So I am not sure now, I cannot provide the answer now on whether these are translated, but I think that transliterations are allowed.
Okay.
But in any case, I recommend to check the UPOV explanatory notes.
Yeah. Thank you. And what is, excuse me, what is the exact timeline to provide a final denomination, especially in case of takeover of the US report?
Okay, so Indeed, as I said, the checking of the plant variety denomination is part of the substantive examination of an application for a plant variety right. And actually, the applicant does not need to provide a denomination proposal at a first stage. Like you need to provide, of course, an identifier, let's say, at the beginning, but you can propose the denomination at a later stage. And then what is the final timeline? The final timeline, it's established in Article 29 of the proceedings regulation of the, of the CPVR system. And then in this proceedings regulation, if you go to this article, it is indicated that you can propose a denomination up until the time when the final report of the technical examination is received by the CPVO, because of course the technical examination is carried out by an examination office in one of our examination offices, and we have offices all over Europe carrying out this task. And once we receive from them the report, then the denomination can be is the final time limit to propose a denomination. And then yes, in the case of the takeover, it's the same as soon as we have the report with us as the final report for the technical examination, then that marks the time limit to send the proposal.
Thanks. Then question number 4, who determines that a variety is no longer in existence?
Yes, yes, this is a tricky aspect because, of course, this is a very difficult thing to prove. Like, how do we know that a variety is no longer in existence in all the world? I mean, this can only be an assumption. So, of course, we assume that after a certain period of time, when the variety is no longer commercialized, when we don't have evidence that it's in a, let's say, in a bank of seeds and so on, in those cases, then we assume that the variety is no longer in existence. However, any third party can actually come to us and say, like, well, actually, yes, the variety is in existence, because I think that this question refers actually to the reuse of denominations, because sometimes after a certain period of time, so from 10 years from, let's say, the deletion, 10 years from the expiration of the deletion of a denomination from a register, then technically a denomination could be reused, although UPOF does not recommend it. But there is this time limit that applies. And then there is always a third party that can come and actively indicate that the variety is in existence. And then, of course, the CPVO then takes it into account. So there is always a way to inform us about it, and then we will take action thereon.
Thanks a lot. And the question number 5 is between a potential contradiction between trademarks and plant variety rights. So is a trademark in class 31 covering all goods for class 31 and anteriority, even if goods are not of the same species or close related species than variety of a proposed denomination? As an example, a trademark is used for grapes but is covering all class 31 products. Does it anteriorize a variety denomination for beans as well?
Okay, I think I see what the question aims at. So, of course, the thing with trademarks is that you can register them for all goods in class 31. So if you indicate all living plants, for example, this would include like any genera, any species, and then there would be a conflict.
Yes, I think so.
And then the idea is that the trademark cannot be registered in relation to the species or a closely related species of this variety which the denomination designates. So there must be no direct conflict. If it's in another, let's say, market sector, if it's like a grape and we have a bean, then this should be fine. But here in the example that the person is, that this user is addressing, the user is referring to covering all goods. So in those cases, what we could do, or what EUIPO could propose, and then it's a limitation of the goods and services. So then you say all living plants except for, and then you explicitly exclude the species concerned or the genera concerned, so that there is no conflict.
Yeah, maybe also interesting would be to see whether actually that trademark has been using only grapes, or maybe it has been used also for beans, because in case it hasn't been used then for a long time for beans, perhaps it could be an automatic limitation for the trademark. But that's becoming quite
Yes.
a trademark
Yes.
discussion.
I know that this is one of the issues sometimes with trademarks, that they are
Yes,
registered for
no
a
use.
whole range of products, and then in practice they are not used, and then they can be, however, liable to cancellation. So there is always the
Correct.
chance to anybody to point it out. So yeah,
It could be also a potential solution. And now
yes.
on the question number 6, is the holder of a plant variety right entitled to prevent the use of a denomination by third parties, even if it does not hold the trademark? Wait a sec. Yeah, I would say that a plant variety right is sufficient. So I think maybe the question here is saying that you need a trademark and a plant variety right in order to prevent the use of a denomination, but I don't think that is the case. Just if you
Yes. Well,
understand it differently,
yeah, let's see.
just go.
The idea, well, is that the holder cannot prevent the use of a denomination. They cannot prevent it because, first of all, the holder is obliged to use the denomination when commercializing the plant material, and then also any third party commercializing the denomination, sorry, the variety must use the denomination. And there is actually a provision both in the UPOV Convention and in our regulation that states that the free use of the denomination shall not be hampered by any other use of any other designation. In the case where there is a prior trademark, then this can be an exception, and then there could be, I can imagine, a conflict. But if there is a trademark application after a denomination is registered, then this trademark should in the first place not be allowed. But then, of course, you can commercialize your variety, of course, with the denomination, but you can also commercialize it affixing in the package as well the trademark.
Okay, thank you very, very much. I think you understood it better, the question, than I did. One last question from Nada, who's, by the way, congratulating you very much for the very interesting webinar, Ángela. She says when or whether you're going to be able to take a look at the recording, and that's pretty much always possible, because besides having the link for look at the webinar once again, once the webinar has taken place, so once you will receive the follow-up email, you also have the chance to visit our e-learning page, where this webinar is also among all other webinars that we have carried out. I will update, of course, the version of the newest webinar, so the one of today that has just taken place, and you can either go there on the learning page or use the link that you're going to receive. Important is that you can also take this link and send it, not sell it, send it to anyone you'd like without any form of limitation. The only thing anyone who would like to see the video has to insert name, surname, and email account. That's the only form of limitation. So there are no further questions. I see we're still quite a number of participants, around 60 people. So I thank you all 60 for being with us until the very end of the presentation. Of course, the biggest thank you goes to Ángela for for the speech today and for the slides and the very interesting webinar. Thank you very, very much, Ángela.
Thanks to you.
It's been a pleasure, and I then give you an appointment to the next upcoming webinar. We're going to be here pretty often, as you've seen by the webinar calendar, and of course we're going to be very, very happy to share this time with you. In the meanwhile, I wish you all a lovely lunch and a better afternoon and week as well. Thank you very, very much, and have a nice day.
Thank you. Goodbye.
Goodbye.